Act. So the Land Act is the general legislation that talks about this is the type of land, this is what you do with land. Then there's the Land Registration Act that gives the procedure for registering titles in Kenya. One of the rumors, again, I love Kenyans as a rumor.
Yes.
One of the rumors that came through when this act was passed is that we're going to be asked to take all our freehold titles to be leasehold titles. This is not the amendment that effected that.
Yes. A lot of people were saying, go tell your parents their land is at risk.
It's going to be taken away.
Yes. That has not yet happened. This is Kenya. Let's just say it has not yet happened.
It has not yet happened. Hi guys, welcome to the rundown. My name is Mihala Barasa.
And I'm Danun Zuko.
Thank you for tuning in today.
Yes. If you have not subscribed to our channel, please subscribe. Hit the notification bell so that you can know whenever we drop a new episode. Also, you can listen to us on Spotify and Apple Podcasts. Okay, so let's just dive right in. So in the previous episode, we talked about the Computer Misuse and Cybercrimes Act,
Yes.
which was enacted in October. So there are some reforms that were done to land legislation at the same time. There was the Land Amendment Act of 2025, and there was the Land Commission Amendment Act of 2025, which were assented into law on 15th of October, 2025. So today we'll be dissecting the two laws and telling you what are the changes that were enacted and how do those changes impact you.
Good. That's a nice introduction.
Okay, so to start us off, our resident advocate of the High Court. Oh my, na feel ni kanini. LSK one day will nini.
Will censor you.
Yeah.
They will not. LSK are good people. Lawyers, you are good people. Comment down below and tell her how nice we are.
Oh my God. Yeah, so probably, Mihala, you can start by telling us, what do you think was the purpose of these amendments?
Maybe the question is, what is the purpose of any amendment really?
Mm-hmm.
More often than not is that the legislature has realized a lacuna or a loophole in the law that it feels like it needs to be fixed. What amendment acts come to do for the most part is either to introduce new legislation that affects that area of law or to patch up that which was not provided for in the older act. I think for the most part, the Land Amendment Act of 2025 and the National Land Commission Amendment Act of 2025 come in to patch up whatever it is that was not provided for, or whatever it is that was perceived, let me use the word perceived, to be unclear in the parent acts.
Okay.
Yeah.
Makes sense. So you had, the next time you're in a meeting or a boardroom, don't say a loophole, say a lacuna.
Yeah.
Anyway, so looking at the Land Act, probably you can tell us what are the key highlights that for you in the amendment of 2025.
Maybe we start with the Land Amendment Act because it's a much shorter legislation.
Yes.
When you look at the Land Amendment Act, the Land Amendment Act of 2025, one of the main things that it does is it harmonizes the meaning of the word Registrar of Lands.
Oh.
So the Registrar of Lands, in my view, probably had a different definition in the Land Act and a different definition in the Land Registration Act. Those are two different acts. So the Land Act is the general legislation that talks about this is the type of land, this is what you do with land. Then there's the Land Registration Act that gives the procedure for registering titles in Kenya.
Okay.
So what it did is it imported the definition of the registrar from the Land Registration Act and said, even in the Land Act, the registrar title or the definition shall be the same. What does this have the effect of? It creates a statutory harmony because you can't have two different definitions of the same word relating to the same person. So I think this I think helps in two things. One, harmonizes, gives statutory harmony. And secondly, it removes the possibility of you wanting to hire a registrar under the Land Act and another one under the Land Registration Act. Because this is Kenya and that's a possibility as well. The second thing that it did, it spoke about the registration of allocated public land. So one of the things that it did is it required that all public land must be registered in the name of the person allocated. The amendment says the registrar shall register public land allocated to a public body or institution by the commission being the National Land Commission. So if land is allocated to, say, the Ministry of Health, it should be registered in the name of the Ministry of Health. The other thing that the Land Amendment Act does is it mandates the registration of public land to public institutions. So how does this happen? The public body or institution has to apply the Registrar of Lands to have the land registered. Secondly, the registrar then will register the land to the public body or institution. So if it's land by the Ministry of Agriculture, it has to be registered in the name of the Ministry of Agriculture. Then after the land has already been registered in the name of that ministry, there shall be a gazette notice in the government gazette. Do you know where the gazette is from? Do you know the gazette? Yes. There shall be a gazette notice that will specify the particulars of that registration, and then they'll issue a certificate of title. Now, it goes further to talk about how the certificate of title is prepared. If it's a public entity, the certificate of title shall read the name of the public entity. If it's an unincorporated public entity, that means like it's quote unquote unregistered, then the cabinet secretary or the national treasury shall be the trustee of that land. So it shall be maybe the national treasury is holding this land in trust for an incorporated public entity X. In the situation where it's a county government, then the land is registered in the name of the county government. What effect does this have, in my opinion? It kind of minimizes instances of land grabbing. Because now, maybe Kakamega County, say, has 10,000 acres of land registered in their name. The Ministry of Agriculture has 5,000 acres registered in their name. Public entity X that is incorporated has X number of acres registered in the name of the National Treasury as the trustee. So from my analysis, this amendment is very short. The Land Amendment Act is very short, and basically that is what it provided for. Anything else that you think I missed?
Actually, I think you covered everything. The amendments mainly cover that harmonization of the definition of the registrar. Yes. And also that the registrar shall register public land allocated to a public body or institution by the commission. So I think you've covered all that.
Okay.
So there was also the harmonization of the Land Act with the Land Use Planning Act of 2019. So basically, again, just covers about the registrar. The registrar shall register land set aside by persons or a land buying company for public purpose consequent upon a proposed development. So when things like, when we say there's a road that's coming up, if we're talking about development or infrastructure projects like a road, railway line and things like that, this is where the registrar shall ensure that land for public purpose has been set aside.
Okay.
Yes. So I think you've covered everything that needed to be covered under this amendment.
There's one thing
Uh-huh.
that we've not covered, or maybe I thought I should cover.
Okay.
One of the rumors, again, I love Kenyans and the rumors.
Yes.
One of the rumors that came through when this act was passed is that we are going to be asked to take all our freehold titles to be leasehold titles. This is not the amendment that effected that.
Yes.
It did not do anything like that. So if you had that information, it's not in this one.
Yeah.
Probably you're thinking about another amendment and another legislation, because I think in last year there was a bill. I don't know if it was passed into law, but there was a bill that required foreigners that acquire freehold to change it to leasehold before they acquire title to it.
Yes.
I don't know if there's a new one that now spoke about Kenyans, but this is not that legislation.
Yeah.
Yes.
Okay, I think that makes sense because it was one of the misconceptions that was flying around.
Yes.
Yeah, that there was a change to the freehold and levies and land levies. But from our research, that wasn't
wasn't part of it.
Yes. So I think thank you for clarifying that, Mihala. That's good to know. Because a lot of people were saying, go tell your parents their land is at risk.
It's going to be taken away.
Yes. That has not yet happened. This is Kenya. Let's just say it has not yet
It has not yet happened. To be on the safer side.
To be on the safe side. Yeah. Okay. So I think we've covered most of what was in the Land Amendment Act. Now, I'd like us to now take a closer look at the National Land Commission Act. So the National Land Commission Act is an amendment that was done in 2025. There was a commission that was existent, had been enacted, I think, in 2010. Yes.
After the promulgation of the new constitution.
Yes. Okay, so right now I'd like us to take a closer look at the National Land Commission Amendment Act, which was the second act in relation to lands that was enacted on 15th of October 2025. So basically, in 2010, the National Land Commission came into effect. All right. So Mihala, please take it away.
When we speak about the National Land Commission, I want us to understand that it's a creation of the Constitution. So Article 67(1) of the Constitution of Kenya 2010 brought about the National Land Commission.
Yeah.
But its operations and how it acts and its structures are determined by the National Land Commission Act of 2012, the Land Act, and the Land Registration Act.
Yes.
Like I keep saying in this channel, we start with the Constitution, then trickle it down to the specific legislation that kind of gives a structure to either a body or a law. What was the commission meant to do? The commission was meant to basically help manage public land on behalf of national and county governments, to recommend national land policies, advise the national government on land programs, give research on land, initiate investigations on complaints into present or historical land injustices, that is important, and to recommend appropriate redress. One of the things that they were also meant to do was to encourage application of traditional dispute mechanisms in land conflict. And that is important because laws that were transported from Britain to come and act in Kenya, I think in some instances of land would not fit the local context well, especially on issues like communal land and all that. That's why we apply the traditional dispute resolution mechanism. Another thing was to help assess tax on land and premiums on immovable properties. Now, the commission had a chairman and 8 members. So, before I give you the whole history of that commission, I would like to stop there and then we go into the National Land Amendment Act of 2025. As Ndanu said, it was assented into law on the 15th of October, but its operative date was the 4th of November. So it started its application on the 4th of November 2025. Mpaka hapo tumepatana?
Yes.
Good. I would like to start with 2 important things that the National Land Commission Act did. The first one, it gave the National Land Commission the ability to continue to review grants and dispositions over public land granted to anyone before the 27th of August 2010. Why the 27th of August 2010? Because the new constitution of Kenya came in. We voted for it on the 28th of August 2010, I think. Initially, this review was supposed to be undertaken up to May 2017 because I think the constitution had given a ceiling to the time.
Yeah.
So when that time ended, I think the mandate of the National Land Commission to do that dwindled as well. The other thing that this Amendment Act did was to help the National Land Commission to continue to accept and consider historical land injustices and claims. And these claims were to be lodged by September 2021. So there are claims that the National Land Commission currently has on land injustices, but I think they have not been adjudicated or dealt with because of the fact that that period had lapsed. So these are some of the 2 things that the National Land Commission Amendment Act did. Anything else?
Okay.
Anything on after that overview?
So basically, the other area that I'd like us to look at is the powers that the commission has been given in the amendment. Yeah.
Okay. So I'll start, then maybe you can take something from there.
Okay.
The National Land Commission Amendment Act introduces a section that deals with review of grants and dispositions in land, which, like I said, it reinstates NLC's authority to review grants and dispositions on public land.
Yes.
Now, this is to say that the National Land Commission can initiate such reviews on its own motion, or if there's a complaint by the national government or the county government or the community or an individual, that review can be looked at and it must be completed within 5 years. These 5 years can be extended by parliament. So it's upon the discretion of the parliament to say, okay, this act is coming into force in 2025. By 2030, they're supposed to be done. If they are not done, then parliament can extend. It can extend that period. The good thing about that retribution is it now anchors that process on fair administrative action and natural justice. So this then means that if there's any person that is affected by that injustice or that complaint, they're supposed to be notified, they're supposed to be given an opportunity to be heard, and they're supposed to be given access to all the documents that relate to that dispute. This is in line with an act called the Fair Administrative Act. So let's say the National Land Commission has received papers, has given notices, has had cases on that review. What do? They have to give a determination. That's a decision. That's not a recommendation. A determination is basically a decision. And if it finds that the title was not lawfully acquired, it will tell the registrar to revoke that title. In addition, they can issue other consequential or corrective orders to these people. One thing that stands out in this amendment is that if you purchased that land lawfully, you have to be given notice before that title is revoked. So that does not mean that that title will not be revoked. Yes, it will be revoked, but you will be given notice.
Yeah.
So what happens to the determination that the National Land Commission makes? The determination that the National Land Commission makes is registered in the High Court as a decision of the High Court. And why is it registered as a decision? Because after you register a decision in the High Court, then you have an order. So it's registered as an order of the court.
Yes.
If you have an order of the court, it's easy to enforce that decision. How does this change from what NLC was previously allowed to do? Initially, they could just make recommendations. and they could talk about steps to regularize the titles, but they could not issue a direct order or a direct decision that can be effected. So you still probably would have had to go to court after that recommendation.
Yes.
Last but not least, there is a bit of a push and pull on the fact that if you're a bona fide, whatever you choose to say it, but if you're like a proper purchaser of a parcel of land, your land cannot be taken away or your title cannot be revoked without notice. There's that part, and there's the part in the current law that says if your title is tainted from jump, then you don't have any rights as to that title. So there's that here we are saying give them a notice, but then there's the existing part of the law that says they don't have any right as to that title, because from jump that title was tainted and irregular. Yeah. So in terms of review, I think that has been my understanding of what the National Land Commission Amendment Act does.
Okay. Yeah. That's a good summary of the powers that the National Land Commission has been given. And as Mihala has said, they now have higher powers. So any order or decision that is made by the National Land Commission will be registered with the High Court, and now it will be an order issued by the court. Okay. Then I think you had talked about the commission shall be able to investigate any historical land injustice complaint and recommend any appropriate redress. So probably, can you tell us what would constitute a historical land injustice?
Good. That's a good question. When I was introducing it, I remember telling you guys that the National Land Commission was brought about by the Constitution of Kenya 2010.
Yes.
Then it was operationalized in 2012 by the National Land Commission Act, the parent act. Then they were given a period of 5 years to address historical land injustices, which ended in 2017. So that has been reopened. So they're reopening investigations into historical land injustices. And one of the main features is those investigations need to be completed within a year of them being registered. So if there is an injustice that has been seen or has been reported, then the commission has 1 year to investigate that complaint. So the question that you asked is what are examples of the permissible land injustices? One, it can be colonial occupation. I remember recently watching a BBC documentary about a lady whose, I think, mother or grandmother was one of the Mau Mau fighters, and they were still fighting for their land. I think that could be one of those things.
Yes.
Secondly is land that was lost during the independence struggle. And then there's also development-induced displacement without adequate compensation. So if there's a road or a railway and probably the old Land Acquisition Compensation Tribunal did not compensate you properly, then that would be there. Then there's inequitable adjudication or resettlement schemes. So any injustices relating to resettlement schemes, I think that would be handled by the National Land Commission. This one you should be listening, the Nairobi City County. Politically motivated evictions. So if you are evicted unfairly, the National Land Commission can now hear and determine your claim.
Yes.
Land injustices as a result of natural disasters, corruption, and then there's an additional power that is given to the National Land Commission to approve a course that they can be able to come and say, look, this looks like a historical land injustice and we would like to address it.
Okay.
Yeah.
Okay. I think you've captured it very well, and our listeners will be, I'm sure, able to understand what the historical injustices are, and why this land commission is important. Okay. So as we continue with this analysis of the National Land Commission Amendment Act, so one of the things that stood out for me in this act is anyone who is going to raise a complaint needs to ensure that their complaint is verifiable. Yes. So I found that very interesting. But then, in as much as it needs to be verifiable, but it also provides for space for if you don't have all the information necessary for adequate submission, then the commission is mandated to take reasonable steps to help you get all the available information or ensure the available information has been sourced. So I think that would be good. Okay.
I think for me, the other thing that stood out in that determination with historical injustices was that period of the year.
Yes.
Like, look at my claim and adjudicate it within a year. After you are done, don't hold on to the decision. Publish it in the Gazette.
Exactly.
If my decision is in the Gazette, you're saying, okay, this is not a historical injustice, or this is a historical injustice, and this is what is supposed to be done. I think for me, that felt like a win. And the other thing about it is there's still clarity on what remedies do people have for historical land injustices. Of course, there's restitution. You can be given back your land. There's compensation if maybe it's that road and you aren't given enough money for it. There's resettlement. There's rehabilitation. And there's affirmative action programs. Not forgetting, we initially talked about revocation. A title might be revoked or land might be reallocated. In some instances, the National Land Commission might sell the land and share the proceeds if it's a maybe communal land. And then there's also refund to proper third-party purchasers. So if the title was tainted from jump and I buy that land like 10 years later from a bad title, I am entitled to a refund. And then also, obviously, the court can issue other declaratory or preservation orders.
Okay, makes sense. And following all the forms of redress that Mihala has mentioned, it's good to note that once a determination has been made, then under the Act, then the recommended redress has to be implemented within a period of 3 years. And I think that's quite critical. Okay, so the other thing that I'd like us to talk about is the fact that this act requires the commission to operationalize this act through regulations within 6 months. So you said it comes into force on which day?
On the 4th of November.
4th of November. So 6 months from 4th of November.
By April 2026, we need to have regulations in place.
Yes. So basically, as Mihala keeps on mentioning, we have the Constitution, then from the Constitution, laws are made, then from the laws, then regulations are made. Yes. And a lot of commissions usually run using regulations. Regulations sort of operationalize the legislation.
This like regulations would be what SOPs are for your company.
Yes.
So probably you have your HR manual and then there's your departmental SOP.
Yes.
So the standard operating procedures, that is what regulations usually do.
Yes. Yeah. Okay. So I think we've basically covered most of what was recommended or changed in the amendment of the Act. So I don't know, Mihala, do you have anything you'd like to add to do with the land Act or the National Land Commission?
I think as a good student of my Toastmasters class, I'd like to address 3 important things that come across from the National Land Commission Act.
Okay.
What stood out for me in the National Land Commission Act? 1, there were timelines within which the National Land Commission Act must operationalize its regulations, must finalize its investigations, and must complete the adjudication of historical injustices.
Yes.
Number 2, they also gave an express ability to challenge the determinations of the National Land Commission in the High Court under the Fair Administrative Action Act. So if you don't like what NLC has done, you can go to the High Court. Consequently, they gave us the ability to register the determination of the NLC as an order of the High Court, which then gives it ease in application.
Yes.
So for me, number 1 was timelines. Number 2 was the challenge. Number 3 was the registering of the decisions of the NLC with the High Court, which looks like the Act has given a little bit more power and autonomy to the National Land Commission.
Okay. Yeah. Which makes sense. And thank you for wrapping it up in a very nice way. Thank you for that summary. So today, I hope you have learned something about the laws that govern lands in Kenya and the amendments that came into effect in October of 2025. So as a reminder, if you've not subscribed to our channel, please remember to do so. Please follow us on our social media pages at The Rundown KE on Instagram, TikTok, which other one do we have?
Spotify and Apple Podcasts, where you can listen to us as The Rundown KE. By the way, someone at work asked me, like he was like, I found a channel and I think I heard you and saw you. I was like, yes, that is us.
Yes. That's awesome. Yes. And if you'd like to follow us on our personal pages, I am Ndanu Nzuko on my social media handles.
And I am Mihala Barasa on all of my social media handles.
Until next time,
Bye.